In the meeting of the Presidential Working Group on the National Policing Bill. At that meeting, the Secretary of the Working Group presented the profiles of the Policy Advisory Committee approved by His Excellency President Bola Ahmed Tinubu, GCFR, and briefed members on the implementation work plan, its principal milestones, and the outcomes expected at each stage. Now, this is a monumental reform that Nigerians have debated over for many years. The question before the country is how we transform our policing architecture to become more responsive to the realities of our communities. Thus, our central task is now to design a lawful, professional, and sustainable federal and state policing system that places greater capability closer to the people while presenting national standards, national security, and the rights of every Nigerian. The legislative process has advanced considerably. The Senate approved the State Police Constitutional Proposal on 24th of June 2026, and the House of Representatives passed the Executive State Police Bill on 23rd July 2026. The constitutional amendment is, however, not yet in force. It must obtain the approval required from the state houses of assembly as prescribed under the Constitution. Until that process is concluded and the necessary implementing laws are enacted, there is no operational state police service anywhere in Nigeria, and the Nigeria Police Force remains the constitutionally recognized police institution. Now, this distinction is very important. The constitutional amendment creates the authority, if you like, the permission, and broad architecture for federal and state policing. However, it does not by itself provide the complete operating system. It does not settle the questions on standards, certification, recruitment, training, funding, command, or jurisdiction complaints. It does not address the question of data, firearms, pensions, transition, or cooperation. Those matters must be addressed in the National Policing Bill and in the consequential laws and instruments that will accompany it. Mr. President established the Presidential Working Group so that Nigeria will be ready to act responsibly when the constitutional process is completed. Our mandate is to produce a technically robust, implementation-ready draft national policing bill and supporting legislative package. We are building the legal and operational framework required to move from one federal police institution to a workable dual policing architecture. The assignment includes a preliminary audit of the Police Act of 2020, the Police Service Commission framework, police regulations and other laws and instruments affected by the reform. It includes provisions on national minimum policing standards, objective analysis of state readiness and certification, federal, state, and interstate cooperation, clear jurisdictional rules, independent personnel and complaints institutions, human rights, custody and use of force safeguards, rank equivalence analysis, transfer, secondment and pension portability, criminal information, forensics and interoperable data systems, firearms control, funding, and grant conditions. It includes federal intervention structures and the orderly treatment of existing security outfits, assets, liabilities, records, and pending cases. The working group brings together the institutions that must own and implement these decisions: the Presidency, the Federal Ministry of Justice, the Office of the National Security Advisor, the Nigeria Police Force, the Nigeria Governors Forum, and the Nigerian Bar Association. Its secretariat will conduct the research, legal audit, policy analysis, drafting, data processing, consultation, document control, and preparation of the final transmittal package. The President has also approved a multidisciplinary policy advisory committee chaired by Honorable Justice Mohammed Abdullahi Liman, who's here with us. Its membership draws from the judiciary, the academia, the police and security agencies, justice sector reformists, public policy experts, technology and data experts, the National Assembly, the Office of the National Security Advisor, the Nigeria Police Force, Nigerian Bar Association, the Nigerian Governors Forum, and State Attorneys General. The committee includes direct subnational perspectives with State Attorneys General drawn from across the 6 geopolitical zones. The role of the Policy Advisory Committee is to provide high-level policy and technical oversight. It will test assumptions, identify gaps, review the policy outline and successive versions of the bill, and validate the supporting fiscal, transition, and implementation materials before they move to executive consideration. In a reform of this sensitivity, independent oversight and a documented record of comments and dispositions are essential to both quality and public confidence. The approved work program is a 7-week milestone-driven exercise running from the 27th of July to 14th of September 2026. Administrative and technical preparations have been underway, and today's meeting formally mobilizes the next stage. The resulting executive bill package is scheduled for presentation to the President on the 3rd of September. Subject to his approval, a national consultation on the completed draft will follow. But I think that we have tweaked that so the national consultation will come before the President's final approval. After which, the text and supporting materials will be revised and prepared for formal transmission to the National Assembly. The timetable is demanding, but it is not a shortcut. Legal drafting, policy, research, data analysis, and implementation modeling will proceed in parallel with fixed review gates. The final package will comprise more than a bill. It will include schedules, an explanatory memorandum, a legal audit, and consequential amendments matrix, a clause-by-clause analysis, a state readiness framework, a fiscal and implementation note, an implementation work plan, a validation report, a risk register, and a controlled digital archive. These are the materials required to make the reform defensible, auditable, and capable of implementation. The government is proceeding on a clear principle. Local policing capability must be matched by national safeguards. State police cannot mean 36 state militias, just as national standards cannot become a disguised method of re-centralizing day-to-day state policing. States must have a legitimate policy voice on public safety, but no political office holder should be able to direct the arrest of an opponent, the suppression of lawful political activity, or the selective enforcement of the law. Federal intervention must remain exceptional, evidence-based, proportionate, time-limited, and reviewable. Officers must answer to the Constitution and the law, not to personal or partisan instruction. Operational commencement must also be based on readiness, not announcement. A proposed state police service must demonstrate that it has credible arrangements for recruitment, vetting, training, pay, pensions, equipment, custody, complaints, discipline, data, firearms control, independent oversight, and financial sustainability before it begins policing. National standards will be the baseline. States may establish higher standards. However, no Nigerian should receive a lower standard of protection because of where they reside. Public participation is an integral part of this process. To that end, we are announcing an open call for memoranda, position papers, and practical proposals from Nigerians at home and abroad. professional bodies, civil society, security institutions, state and local actors, experts, and other stakeholders to inform and improve the legislative proposals and other deliverables that the working group will produce. Now, those submissions will be organized by theme and recorded. When the completed draft is ready, the national consultation will allow Nigerians to engage with the actual clauses, the safeguards, funding proposals, and transition arrangements. The process will show not only what was submitted, but how material proposals were considered. We recognize the concerns that accompany this reform: the fear of political abuse, unequal state capacity, duplication of commands, poor funding, ethnic or sectional capture, and the possibility that new institutions could reproduce old failures. Those concerns are legitimate. They are precisely why the constitutional amendment cannot be treated as self-executing, and why the National Policing Bill must be comprehensive, and safeguards are not obstacles to state police. They are what makes state police credible, lawful, and sustainable. This reform will not by itself solve every security problem in Nigeria. No law can substitute for good leadership, competent officers, reliable intelligence, adequate resources, professional discipline, and public trust. But Nigeria has an opportunity to build a policing system better matched to the scale and diversity of the country. A strong federal police service for federal, interstate, and national security responsibilities, and a capable state police services for state and local responsibilities and common standards that protect the Republic and its citizens. Mr. President recognizes this opportune moment and is determined that we as a country will rise to meet this moment together, capably and responsibly. For us on the working group, Mr. President's direction is clear. We have accepted the responsibility and we will achieve our mandate. I thank the members of the working group, the Policy Advisory Committee, the Committee Secretary, the Secretariat, and all institutions that have committed their expertise to this assignment. I also thank the Nigerian people and call on all well-meaning citizens to join us to produce a better and more legitimate outcome by ensuring that this process of designing and implementing a dual policing structure is inclusive, collaborative, and brings all Nigerians together in a joint effort for the common good. Thank you, and we'll now